And it is my pleasure to welcome today alumni, students, and friends to what is now our 5th annual Supreme Court preview. This really is one of my favorite events of the year, in part because of the substance. As lawyers, we all know the role that the court plays in our constitutional democracy. We all know the issues that the court is grappling with and how those issues can affect all of us. And as lawyers, I think we have a special responsibility to stay up to date and abreast about these issues because they really are part of the discussion in our society. And it's the old de Tocqueville notion, right, that lawyers are responsible for making sure that we maintain the rule of law, and this helps all of us fulfill that responsibility. I also like this event because of the quality of the people we are able to learn from, that I think throughout the 5 years, and this year certainly continues that tradition, we've been able to invite some of the leading Supreme Court experts to share with us their views on what's going to happen in the coming term. So in terms of format, I'm just going to quickly introduce the moderator for today's preview, who will then introduce the panelist. So the moderator is Professor Lee Epstein. Professor Epstein is the Provost Professor and Rader Family Trustee Chair in Law and Political Science here at USC. Professor Epstein joined USC last year, coming here from Northwestern, and I think she is the perfect person to moderate this panel because she is the world's leading expert in using empirical methods to help better understand the Supreme Court decision-making process. Her articles have been published in the country's leading law journals and political science journals, and her work is often featured in the New York Times and other major media outlets. So with that, I will turn it over to Professor Epstein, who will then introduce the panel. Lee?
Well, thanks. Is my mic? Yeah. Thanks so much, Bob, for the very nice introduction. As Bob mentioned, we have an amazing panel here today to help us understand what the Supreme Court has been up to and where it may be going this term. Because our participants are so famous, let me briefly introduce them so that we can get right down to the business of the day. All the way to my left, we have Rebecca Brown, who is the Newton Professor of Constitutional Law at USC. As do all of our panelists, Professor Brown has a fabulous resume. She was editor of the Georgetown Law Journal and went on to clerk for 2 giants on the federal bench, Spotswood Robinson and Thurgood Marshall. She later served as the Allen Chair of Law at Vanderbilt. On top of it all, Professor Brown is one of the country's most astute constitutional theorists. I'm so proud she's my colleague, and we are also fortunate that she's here today. To my left, immediate left, is Paul Clement, who too clerked for very influential judges, Judge Silberman on the U.S. Court of Appeals for the District of Columbia, and Justice Scalia. Mr. Clement went on to serve in the office of the Solicitor General for 7 years, 3 as the Solicitor General from 2005 to 2008. Today, Mr. Clement is one of the most prominent members of the Supreme Court bar. He's argued over 60 cases before the court, including, of great interest to us, the healthcare cases. He is now defending the Defense of Marriage Act, DOMA, on behalf of the House of Representatives, and that's another case we'll discuss today. Now, that's Mr. Clement's past and present. As for the future, when you get home tonight, Google him, okay? You'll see that he appears at the top of many lists for a spot on the Supreme Court. We'll see. We'll see. Last, but certainly not least, we are thrilled that Walter Dellinger is here. Professor Dellinger also clerked for a Supreme Court Justice, the great Hugo L. Black. Like Professor Brown, Professor Dellinger is an extremely influential constitutional law scholar, having served as the Maggs Professor at Duke and now as a visiting professor at Harvard Law. And I just learned that Professor Dellinger visited us here at USC in 1972, and that his wife, Anne, who's also here, did 1/27th of her JD here at USC. Like Mr. Clement, Professor Dellinger served as acting Solicitor General. He was also the head of the Office of Legal Counsel during the Clinton years. Professor Dellinger continues to regularly appear before the court, including in a case familiar to many of us, Heller versus the District of Columbia, better known as the Second Amendment gun case. So you can see what a distinguished group we have here today. Our plan for the afternoon is to start with a look back at last term. We'll then move into a discussion of several cases the court has already agreed to decide, as well as a few that it may or may not agree to hear. Time permitting, we, and especially I, would love to hear the panelists' views on the future of the court against the backdrop of the upcoming presidential election. But please be assured that we will leave some time for your questions at the end. Okay, so let's get started. Today is an event that is billed as a preview, but it's hard not to review the most eagerly awaited case of last term over the constitutionality of the health care law. This is a complex and complicated decision, and so what I'd like to do for the panelists to discuss is to break the decision down into the two major components of the law that were at issue. The minimum coverage provision, AKA the mandate, and the the Medicaid expansion. So I'd like to start with Professor Brown and ask you if you would provide us with a brief summary of the mandate issue and the court's holding on the mandate.
Sure. There are really three things I think at stake in this issue. One is, what did the court do? The second is, what does that do for the state of the law, implications for new cases and other things like that? And the third is, more broadly, what does it mean and what can we learn about the court and other things from these decisions? I'm going to just do the first one so that we can get our experts to talk more about the other two, which I think you will probably share my feeling of being eager to hear what they have to say. So I'm going to try to be brief and just laying out for those of you who, were in Timbuktu since last June and haven't heard about the health care case holding. Let me just, as simply as I can, lay it out. If I'm too simple, feel free later to ask questions and I can fill it out. I'm talking only about the individual mandate. So the statute contained a provision requiring every person to maintain what was called minimum coverage of health insurance. And that minimum coverage depended on the person's income. And it turns out that, of course, as any of you who are lawyers know, and those who are law students may be learning, when Congress passes a statute, the presumption is that it can't do so unless it can justify a source of its authority, offer a source of its authority in the Constitution. This is different from state laws, but for federal laws, it's a government of enumerated powers, and what that means is that before the law can be passed by Congress, Congress has to invoke one of the list of enumerated powers that the Constitution offers. The most common of these is the power to regulate commerce among the several states. And trying not to go into too much detail, there's so much to be said and has been said about the Commerce Clause, but it is the source of most of the authority for most of the laws that you're familiar with, even those that aren't obviously commerce. Air pollution, clean water, most of the things that Congress passes are passed under this law. So one of the possibilities for a source of authority to pass the individual mandate was this Commerce Clause that I just referred to. And so the issue there from constitutional point of view is requiring a person to maintain minimum coverage a regulation of commerce among the states? That was the constitutional question presented. There were a lot of different views about it in advance of the case, speculation. The challengers of the case argued that it was not within the power to regulate commerce because if a person doesn't have health insurance and they're being told to have it, by definition, they aren't in commerce yet. And in effect, the mandate requires people to enter commerce from a state of not being in commerce, and that is not regulation of commerce. Many people thought that did not have much support in the case law, including many law professors, both conservative and liberal in advance. But it turns out that position did garner 5 votes on the Supreme Court. However, contrary to the early announcements when the decision was being handed down, that wasn't the end of the story. 5 justices did agree that this individual mandate did not flow from the exercise of power over regulation of commerce. However, the Chief Justice offered an alternative, or accepted the government's alternative ground. The government had offered 2 sources of authority for Congress's act, and the second one was that it fell under its power to tax. So, of course, another thing Congress has the power to do is lay taxes. And the Constitution acknowledges that power. And the only limit there, expressly in the Constitution, is that Congress has the power to tax, more or less, for the general welfare, I guess. And so the question was, could this be understood as a tax? And the Chief Justice accepted the argument that, for the following reasons. It may not sound like a tax to tell you to buy health care, health insurance. However, the way it was structured was that a person's minimum coverage was calculated based on tax data, like taxable income, dependents, and all that's the same kinds of things that determine your tax liability. Secondly, it was enforced by the IRS. And how would you pay this penalty if you did have to pay it? That is, if you didn't have health insurance, how would this penalty be assessed? Through your taxes. You would add them to your taxes, and if you didn't pay them, it would be the IRS who would come after you. So basically, for that, it's simplified, but for that general reason, the Chief Justice thought that this really did look like basically a tax on not having health insurance. And he thought that, as understood that way, it actually was consistent with the precedent and the theory underlying Congress's power to lay taxes. So he wrote an opinion joined by not the 4 conservative justices who thought it failed under the Commerce Clause, and joined Chief Justice Roberts on that ground, 5 justices. But it's a different 5 justices, Chief Justice Roberts plus the 4 usually considered more liberal justices on the court, joined to determine that it was, in fact, a tax. And I think that's enough for me, and we're going to move on to the other issue in the case.
Yes.
And can I just follow up by sharpening that even a little bit more, which I think it's 100% accurate, I agree with every word of it. But I think what's interesting is I don't think it's really an overstatement to say, Walter probably does, but I don't think it's an overstatement to say that the court really struck down the individual mandate. And the reason I say that is because, Chief Justice Roberts, in his opinion, was very specific that the statute as written really was, as you described it, a mandate to have insurance. You must have insurance or else. And in order to construe it as a valid exercise of the taxing power, the Chief Justice was quite explicit that he wasn't interpreting the statute in the same way. He wasn't even interpreting it in what he said was the most straightforward way. He was actually kind of recharacterizing the statute, not as you must have insurance or else, but as you suggested, as a tax on those who don't have insurance. And there's 2 things I think that are interesting about that. That's why I wanted to sharpen the point. One is that you can ask, and Justice Ginsburg did rather pointedly, all right, Mr. Chief Justice, Mr. Judicially Restrained Minimalist, what business do you have saying this is unconstitutional under the commerce power if it's valid under the taxing power? The usual kind of, judicially restrained, judicially minimalist approach would be if Congress has authority under one font of authority, you don't have to talk about how it doesn't have authority under 1 or 2 other fonts of authority. And in response to that pointed challenge by Justice Ginsburg, the Chief went out of his way to basically say that the reason I can address the commerce power is because that's really the mandate that Congress wanted to impose. And the reason I have to address that first is that's the straightforward reading of the statute. I then get to the taxing power only second because it's really kind of a contorted reading of the statute, but that's what justices sometimes do to save a statute from constitutional peril. But he really did sort of focus on it really being a little bit different. So that brings me to my second point. The other reason I think it's interesting is that I'm not sure the law will be as effective as construed by Chief Justice Roberts as the statute that Congress actually passed. Because most people are law-abiding. And so if you tell them you have a federal law obligation to go get insurance, they're going to do it. I think if you tell them there's a tax on not having insurance, then what they're going to do is ask, well, how much is the tax? How much is the insurance premium? And sort of figure out whether it makes sense for them to pay the tax or buy insurance. And I think that will result. I mean, I don't know. I guess we'll have to get the empiricists in to actually run some numbers. But I think over time that's going to mean that there will be less people with insurance, i.e. more uninsured, than there would have been if the court had upheld the individual mandate, qua individual mandate on the Commerce Clause.
And isn't it true that the statute says the tax cannot exceed the cost of what insurance would be? So there's a ceiling that it will never be more.
Exactly. And my understanding is that, for some people, it's, there isn't that much of a delta between the insurance premium and the tax. But for some people, there's a pretty significant difference. And so I think those are the people, if they bring out their calculators, may decide that it's actually the rationally economic choice to not buy health insurance but to pay the tax, especially because another sort of dirty secret, and this was true of the law as passed and as construed by the Chief Justice, is it's not really entirely clear how the IRS is going to be able to robustly enforce this tax. So that's another kind of contributing aspect of it. But we'll see over time how that plays out that way.
I would certainly be interested in Professor Dellinger's view on either point 1 or 2 or both.
I actually agree. Is my mic on? Good. I actually agree with Paul that it's certainly fair to read the opinion, contrary to the way it was written up, as invalidating the individual mandate. There are two provisions, 5000A and 5000AB. One of them says that every covered person shall ensure that they and their dependents have minimum adequate health insurance. It's the second provision right after it says that if you fail to do so, you pay a fairly modest 2.5% at its highest if you fail to maintain insurance. So in a sense, what the court did was to hold 5-4, accepting Paul's argument that the Commerce Clause did not give Congress the power to impose a mandate that you shall have insurance, but that nonetheless it was still valid to have the remaining part, though it doesn't fit nicely with the language. It was still valid to say, if you don't maintain minimum coverage, you pay 2.5%. Now, Paul, my only difference with you would be that I think that's very close to what the Solicitor General had already said going into the court, a provision in the Solicitor General's brief that I really thought was important when they, I think, finally put it in the reply brief. Are you a lawbreaker if you decide not to have insurance and pay the penalty? Well, now after the Supreme Court's decision, the answer to that is clear. You're not a lawbreaker if you pay the penalty. But the Solicitor General told the Supreme Court, you're fully in compliance with the law if you decide not to have insurance, but to pay the 2.5% with your income tax. The challengers had said, what does someone say? The reason it's not just the tax is if someone asks you, have you ever violated federal law and you willfully fail to have insurance, don't you have to say you violated federal law? And the Solicitor General, whose view I think on that comes close to being a dispositive utterance, because he's speaking for the United States, says you're fully in compliance with the law if you pay the penalty. So I think that's not much of a disagreement, but the Solicitor General had already signaled, though I agree with you. In Massachusetts, where a former governor, I don't remember his name, who had sponsored a plan similar to this, what is interesting is at a similar penalty, it became a matter of sort of civic duty, so that members of the Boston Red Sox, the members of the Boston Bruins, the hockey team, were all in public service announcements saying, it's the law, everybody should have health insurance. And that really helped speed the spread of health insurance and made the system much more rational in that state than it is. So I think once it's become Obamacare, there are people who will in some sense resist it in a way that it wasn't resisted when it was seen as a matter of patriotic duty. But I thought what was critical all along was the fact that you could treat the 2.5%, if not treating it separately, the penalty that you pay, treat it as greatly mitigating this notion that this was the end of liberty as we know it in the Western world. To me, I always thought this was an easy case. At least 5 justices of the Supreme Court did not agree that it was easy, so I acknowledge that. I thought it was easy in the sense that, is this a regulation of commerce among the states? The sale of health insurance constitutes about 1/6 or 1/7 of the national economy. Of course it's a regulation of a critical part of the national economy, and the question is, was the means chosen by Congress one which gave rise to the sense that there's something so extraordinary here? Well, then my reaction to that would be, no, if you go to work in the national economy, that's a prerequisite to having to pay any penalty under this whatsoever. And if you go to work in the national economy, they tell you on your first day, you have to pay 7.5% for Social Security for your old age subsistence. You have to pay another percentage for Medicare to fund medical treatments when you're over 65. Oh, and now you also have to pay 2.5% if you don't maintain minimum health insurance coverage. Nobody in the world would say, no, those first two are fine, but the last one, the 2.5%, is the end of liberty as we know it in the Western world. So that I thought in that sense it was utterly unremarkable. And if the court said, and what was said to be a Commerce Clause holding but has heavy tones of substantive due process, that you can't require people to go into the private market and purchase a product, at least they can say, well, you may not be able to force them at the point of a gun, force march them, with black helicopters down to the insurance agency. But you can say, look, you can pay a fairly modest penalty if you don't buy insurance. That's all that was involved, and in that sense, I thought it should have been an easy case.
Let me follow up a little bit, and maybe in a slightly different direction. I'm wondering, and all of you can take this on, what you think the long-term implications are of the Commerce Clause aspect of the decision for congressional authority.
Well, I mean, I can start, and I can actually both answer the question but also segue off of what Walter just said. I mean, Walter has been incredibly consistent because he said from the very beginning the Commerce Clause arguments were frivolous. He said that, on the eve of argument and notwithstanding that 5 justices disagreed, you're continuing to make a very persuasive case. And in some ways, I think the significance of the court's resolution is notwithstanding there's a very credible case to be made, 5 justices disagreed. And I think that's actually more significant than you might think because, people have gotten used to the idea that the Supreme Court is divided 5-4. But people have also gotten used to the idea that of late, unlike the historic trend, presidents seem to have gotten better about replacing justices that vote a lot like the justices that were stepping down. So that we've had this period where, in a relatively short period of time, we've had 4 new justices. And there certainly are consequences of that. I think most particularly the substitution of Justice Alito for Justice O'Connor. But still in all, given that there have been 4 changes in personnel, it's actually pretty surprising that there haven't been too many real changes in doctrine. And I think federalism and the commerce power is one area where there could have been. Because if you think about the 2 new justices who ended up essentially accepting my argument, rejecting Walter's argument, they are 2 individuals who really kind of cut their teeth in the federal system. And they replaced 2 justices that really grew up in the state system. So Roberts for Rehnquist, Alito for O'Connor. That's really 2 justices who, their formative legal experiences were in the federal system, in DOJ. And to be sure, Chief Justice Rehnquist was head of OLC, but his formative experiences were in the state system, as with Justice O'Connor. So there was reason to think that, a Chief Justice Roberts, a Justice Alito, would not have the same kind of instinctive, sort of
States' rights.
positive
Absolutely.
view about the states' rights
Right.
project.
Right.
But it seems like in this case that notwithstanding the chief's ultimate vote on the taxing power, that these justices are looking at these issues a lot like the justices they replaced. And I think that's, to answer your question, that's the long-term significance, which is you now have, continue to have what you had before, which is at least 5 justices that think that this idea that the federal law is different from state law because you have to be able to point to one of the limited and enumerated powers. You have 5 justices that think that's really important and think that the one thing you can't have is a federal government with plenary authority. So I think, for me, the important thing is, as advocates, as citizens, the court is going to continue to be in this federalism business going forward. And if one of those 2 justices had a different view and thought the case was as easy as Walter thought it was, then that might have really signaled a pretty significant shift.
But could I just say one thing
Yeah,
about that,
sure.
which is, I think there might be another explanation, though, different from Roberts and Alito maybe being closet federalism guys. I mean, they may have some of those instincts, but I think what Walter said is is really critical, which is I don't think this was really a federalism case. Nobody was saying leave it to the states. This isn't like the gun control case or the marijuana case where the question is either the federal government does it or the states do it. People here were talking about it as an individual liberty question. And even though it wasn't couched that way,
Yes.
it was being read into the Commerce Clause, this idea, it's just, there are certain things that we aren't made to do as Americans. And that, I think, has a substantive due process feel to it. It's just like it's similar to privacy and other. And so I think that my read of Roberts and Alito's vote or instinct in this case is not that they were trying to protect states' rights, but that they were trying to protect what they viewed as individual liberty. So I think that could actually portend stuff for the future, maybe a revival or increase of the substantive due process in more economic spheres, which we haven't seen before. It might be a possibility.
So to translate, that would amount to more stringent look at economic type of legislation?
Right. I totally agree with Rebecca that there's a heavy strain of economic due process, property rights, contract rights that suffuse through this case, particularly in the oral arguments. They were asking questions like, I believe Justice Kennedy or Justice Scalia, Paul was asking questions like, isn't this really a matter where you're going to have the young and healthy subsidizing the older and weaker? Isn't that really what's going on? Well, the Solicitor Generals are telling us, yes, we do that with Social Security. I mean, that they were raising the fact that their redistributive qualities to some of the costs that go, as if that were an argument in itself, which seemed to me, whatever one thinks about it, has little to do with whether it fits within a regulation of commerce. So that there was that undertone. Though I also agree with Paul that if asked in advance what I thought the major differences would be in replacing O'Connor and Rehnquist with Alito and Roberts, I would have thought these are less likely to be states' rights people than someone like Sandra O'Connor, particularly who was a state legislator, very much a person of the West. John Roberts had the same kind of law practice or similar to what Paul has at Bancroft, what I have at O'Melveny and Myers. You represent a lot of major companies see states' rights as laboratories of experiment that are experimenting on them. And so the business community wants to see one system of regulation, not 51. And so that kind of sort of freedom from regulation interest tends not to be a states' rights interest, and that's the sort of the environment that both Roberts and Alito were in the Solicitor General's office defending federal primacy, and then in practice with with the kind of cases that John Roberts did. So there was no reason to think that that there would be anything like a state legislature. So it is significant that there is this, if not a defense of the states, Rebecca, a constraint on Congress, on the authority of Congress, which also is a theme that emerges in these cases from last term.
And if I could just make two really quick points, just in response to really Rebecca's point. I mean, I don't disagree with the thrust of it, but I'm sort of duty-bound to add two caveats. The one caveat I'm really duty-bound to offer is, so my clients in the healthcare case were 26 states. And I was specifically asked the question, so can states impose an individual mandate? And my answer was absolutely, you bet. So in that sense, even though it wasn't really argued principally in terms of states versus federal government, there was no question that my position on behalf of my clients was, this is something that the states with plenary power get to do if they want to, and this is something that the federal government with limited and enumerated powers doesn't get to do. But the second point, and this is less duty-bound, but I think it's interesting, is that I think that although you're right to point out the sort of individual liberty versus kind of federalism, I think the 5 justices, and probably more particularly than anyone, Justice Kennedy, would say that at some level that's a false dichotomy. And there was a case I argued actually the term before called Bond against the United States, where the issue was whether somebody had standing, kind of an easy issue actually, sometimes even easy issues get to the Supreme Court, whether an individual who is criminally prosecuted under statute has standing to argue that the statute is in violation of 10th Amendment principles or Commerce Clause principles, or whether those rights somehow belong only to the states. And in a unanimous opinion for the Supreme Court, Justice Kennedy made the point that federalism in our Constitution does not exist just to protect the states. It exists precisely to protect individual liberty as well. And if you go read the opinion, you'll see. He really warmed to the topic. And so, I think that in fashioning our arguments in this case, we really tried to embrace the fact that some of the justices view the individual rights sort of structural federalism dichotomy as less a dichotomy and more of the idea that the structural provisions are there not to protect separation of powers, the federal government or the states, but are there to protect individuals as well.
Well, before we move on to the Medicaid expansion, I just have to ask the panelists probably the question I get most often from citizen groups about this case. We have heard from reporters that it looked initially like Mr. Clement won the whole case, right? That Chief Justice Roberts had voted on the tax and the commerce issue to strike the mandate, and that he changed his vote. And I'm wondering if the panelists have any views on, if that's so, why he changed his vote, and whether you see that as causing any problems this term on the court. Professor Dellinger, you want to take
are you passing on that?
You want to take a shot?
I will only make the following observation and say nothing further, which is I think there ought to be a rule that if this sort of thing happens, and I'm not saying it did, I'll leave that to others, but if this sort of thing happens, they ought to bring the advocates back and give them another crack at what's now currently bothering the justices. So that's my modest proposal.
I don't know what happened. But I do think that the notion that there is such a hard and fast thing as someone switching their votes at the last minute doesn't quite map onto the process that the court follows. Because there's only one vote that matters, and that is when the opinion writer says, this is my opinion, and other justices say, join me in your opinion, right. And they're 5. The court conferences after oral argument. In a case like this, they obviously would have been discussing the case before oral argument. The court has its private conference. They go around. They cast votes. If there's anything like casting a vote, it's more tentative than that switching would lead you to believe. And in this case, the Chief Justice would have known, since on the issue of the mandate/tax, he knew he had 4 votes either way. So the outcome is going to be whatever he writes is his opinion. If he votes to invalidate it, he's going to have 5 votes, and if he's going to uphold it, he's going to have 5 votes. So he's in control, and he assigns the opinion to himself. And it would seem relatively clear that he told his colleagues, I would assume, that he agreed that it could not be justified as a commerce power. how definitive he was on what he thought about whether you could construe it as an exercise of the taxing power when the Solicitor General says it can stand alone. Who knows? So it's only, I think, when there was I'm concerned there seemed to have been leaks because about the time his opinion would have circulated, there was a flurry of comment, particularly among conservative commentators, about is the Chief Justice waffling, whether that was just lucky or not, I don't know. But it's just not clear to me that there is ever something as dramatic as a switch of a vote when the process of circulating opinions and justices deciding finally to join opinions or not goes through.
Could I just beg to differ on that? Because I clerked the year Bowers versus Hardwick was decided. Bowers versus Hardwick went in a conference. It was 5-4 to strike down the same-sex sodomy statute. And Justice Blackmun was assigned the opinion. He started writing the majority opinion. It was going to be a ringing endorsement of Roe versus Wade, which he had also written. And this is all public. I didn't talk about it for years, but when it was published in the Administrative Law Journal, I figured I was allowed to say it too. Justice Powell then announced that instead of being on the side to strike down the statute, he decided to join. Before any opinion circulated, it was not just, oh, I don't like the way you've put it. He said, I'm now on the other side, and Justice Blackmun's majority opinion became a dissent, and majority was written. And I have to say that I mean, Walter knows more than I do about court practice by far, but I read the dissent by Justice Scalia and the others, and it has a real tone to it that is not characteristic of usual dissents. It looks very much to me in some respects as if it had been written as a majority opinion and changed.
My sense of writing it as a majority opinion is that if you know that the decision is in the hands of the Chief Justice, and if you hope that he's going to change his mind, or you hope he's going to wind up where you are, you want to write your dissenting opinion so at the very end of the process, it can become a majority opinion. You obviously would write it that way. I've seen justices who are dissenting making sure they're ready to make it a majority opinion if they can convince, usually Justice Kennedy, to come their way at the last. I don't. Given that Roberts had the opinion, I think he was always in control, and so whatever he's going to write is going to be the result. And it's not as if the opinion is going to flip. He circulated an opinion. There was plenty of time for the dissenting justices to write it more as a dissent. They had a month after he circulated his opinion, upholding it on the tax power. But the truth is, we don't know, right? We don't.
We can agree that it's angry, though.
Paul may know, but I don't.
We won't know until the papers are released.
There you go.
40 years, 50 years from now. All right, let's just, before we move on to this term's cases, I just wanted to briefly talk about the Medicaid expansion. Mr. Clement argued against its constitutionality, and my guess is if you had polled con law scholars at the time, probably 90% would have bet against you. You won. And I'm hoping maybe if you could just briefly tell us what was at stake and what the court said.
Sure. Well, what's at stake is actually something quite significant because we talk about, as we all have, that the federal government is a government of limited and enumerated powers. But the Supreme Court has long ago said that the federal government can do things pursuant to its spending power that it can't do through its other powers. And there's not that much that the federal government can't do through its other powers. So the best example of this is the one thing that it's crystal clear the federal government can't do, thanks to the 21st Amendment, is tell states what drinking age to have. Okay, that's something the states get to do. But the Supreme Court made clear that they can say, look, if you want to get your full tranche of federal transportation funds, you better raise your drinking age to 21. And Congress did that, and it was challenged as a violation of the spending power, and the court upheld that. They mentioned in that case, as they had in a few previous cases, though, that there might be some outer limit, that there might be some sort of congressional statute that attempted to use the spending power in a way that was so coercive that it would effectively be no different from a direct command to do the same thing, and therefore, if that happened, it would violate the spending power. But that was out there as just a glorious dictum, and it's, and I've tried this. I mean, if you go to lower courts and all you have is dictum, you tend to lose. And so, lots of states and other federal funding recipients in the wake of this decision had tried to argue that a federal spending program was coercive, and they'd all lost in the lower courts. And I think that's one of the reasons that a lot of people thought this claim was really going nowhere. But we kept on pressing it for really two reasons. One is, it did seem important to my clients, the states, that, that if there really weren't a limit, if this were just kind of Lucy in the football and Charlie Brown was never going to get to kick the football, there really wasn't a coercion limit, then it sure would be nice to just know it. And kind of combined with that was the point that if ever there were a federal spending program that would be vulnerable to a coercion challenge, it would seem to be the Medicaid program, because it dwarfs all other federal spending programs. It's enormous. And so the idea that Congress could basically tell the states, look, if you want to keep your federal Medicaid fund, you have to do X. I mean, the idea that that would be a meaningful choice for the states to kind of get out the calculators and decide whether they want to do X, I mean, that really wasn't the case. I mean, the states would have no practical choice given the enormity of the program. And so that's why the states kept on making this argument. And there was a particular feature of the Medicaid program that I think ultimately became its undoing for these constitutional purposes. And I mean, you said that 90% of the law professors would have said we were going to lose. I think you could have gotten into the very high 90s if you would have said.
I didn't want to go
well,
that
no,
far.
but at very high 90s if you would have said, what are the odds of us getting 7 votes? Which is ultimately,
Yes.
there were
That-
7 votes to say this aspect of the statute was unconstitutional.
That's right.
And I think the reason there were 7 votes ultimately, other people may have other speculations as to why. But I think there was this particular feature of the Medicaid program that was its undoing, and that is the Medicaid program expanded to tell the states that they really needed to cover individuals who were basically between 100 and 133% of the poverty level, that they had to provide health insurance for those individuals. And in most states, that was a pretty radical expansion of the program because, again, roughly speaking, most states covered up to about the poverty level, but not above. And what was interesting is the federal law, for other purposes, really treated these new funds to get from 100 to 133% as distinct. And they set them aside, and actually the reimbursement formula was different from those funds. So they really were a distinct group of new funds for the states. And yet, even though they made those funds distinct, they said that if you don't take the new funds, you lose all of your funds, including all of your previous participation. And most of these states have been participating in Medicaid for 40-odd years. And so when Congress said, look, if you want this new basket of funds with its own new conditions, you're going to have to take those funds or you're going to lose your entire ability to participate in the program. And I think the court said essentially on 2 grounds. 1, a lack of notice, and 2, that it was just too coercive. That's what they focused on to strike down the statute. And that's the provision, particularly the provision that allowed the Secretary to take away all of their funds that was struck down as unconstitutionally coercive.
I just have a question for Paul. What do you think this means for provisions like Title IX in the following sense? State universities, Caltech, University of North Carolina, often are quite dependent upon federal funds. If you have a major defense-related research institution, you've got a cyclotron that's being supported by continuing federal funding, and you've already built it, and Congress says, now we have a new requirement. If you receive federal funds, you may not discriminate against on the grounds of gender, on the grounds of sex. We call it Title IX. Well, a state university may think, or the Solomon Amendment, which is no longer relevant given the end of Don't Ask, Don't Tell, but it used to be that if you wouldn't let military recruiters on campus, you could lose all of your funding. Now Nobody thought those were sort of unconstitutionally coercive, but certainly the universities that had defense spending, healthcare spending thought, we have absolutely no choice but to accept the new requirement that we let military recruiters on, regardless of their policies, that we don't discriminate on the grounds of gender. Where do you see this? Are those necessarily entailed, or is there some other step the court would have to take? How do you, I know you don't have an answer to whether they're up or down, but what's the analysis as to how it might be different from this?
Well, there's one way that sort of Title IX in particular might well be different, and it's actually one way in which the Solomon Amendment case and the Fair case might be very relevant, which is, the way that the Fair case was ultimately resolved was not as a spending clause, unconstitutional conditions case. The court basically said, Congress could impose this requirement on the universities even without regard to taking the spending. And I think there's probably by its military power, and I think you could make a similar argument that maybe Section 5 of the 14th Amendment would allow the federal government to impose Title IX type requirements wholly independent of the spending. And that would be its own controversial case. But that's one way you might deal with them. And then, I think, there obviously are going to be efforts to distinguish this spending clause aspect, the spending power aspect of the case, and precisely because, I started this by talking about how the Medicaid program is the biggest federal spending program. There's really nothing else like it. All the arguments we made about, if there is going to be this limit, it has to apply here. People are going to take those arguments and say, well, this isn't like Medicaid. This is nothing like Medicaid. It may seem really bad, but, life's full of tough choices, and this isn't like all your Medicaid funds. But I think that's going to be the nature of the dynamic. The only other thing I'd like to say, though, is, this is the part of the case that, you almost have to go to a forum like this to hear anything about. I think in a lot of people's mind, the healthcare case was about the individual mandate. And yet, in a weird way, I think this may be the part of the case that has more ramifications going forward, because you may have a different view. I rather doubt anybody, put the constitutionality aside, just because of pure politics. I'd be rather surprised if anybody says, hey, I got a great idea. Let's impose another individual mandate. Right. I don't think that's going to happen. So I don't think we're going to really see too many follow-on cases in that area. But there are tons of federal spending programs out there, a lot of which put a lot of funds on the line for relatively small impositions on the states, and I think there is going to have to be a jurisprudence that tells us what's the scope of this spending power decision. And over time, it may be quite limited. Over time, it may be broader. But I think there's probably going to be more action on the spending power. This case will be cited in the lower courts anyways, more for its spending power holding than probably for its commerce power.
Absolutely. I was counsel for the Democratic leadership of the House and Senate, filing two briefs, one in support of the individual mandate and one on the spending clause power. And in meeting with the members and their top staffers of all the relevant committees, people came to the mandate thing, and here's what we're going to say in the brief, and it was fine. But when we got to the spending clause issue, the room was like this. And they were saying, they can't be serious, because, one person said, if they strike down, find the use of the spending clause coercive, we just ought to send the keys to the House and Senate over to the Supreme Court and say, that's what we used to do, is to decide what condition to put on spending. Just take over now. So certainly I think the view on Capitol Hill was that in terms of what Congress might actually do going forward, that the part of the case in which Paul prevailed is actually going to have more significance than the part that was politically important, and I think important in terms of the health care law going into effect.
Yes, that's why I wanted to raise it, because I do agree. I think the longer-term implications of the spending are greater than the Commerce Clause. All right, let's move on, though, to move forward to a few of the cases that the court has agreed to hear this term. And I want to begin with the case of Fisher versus the University of Texas. At least on my reading of the press and the blogs, this case has gotten the lion's share of attention this year. And Professor Brown, can I come to you for a brief description of what this case is about and why it's gotten so much attention?
Yeah, I'd be happy to answer that question. I want to ask the experts next to me, though, why the court took this case. But I'll tell you what the case is and what the issue is. So in 2003, in a case called Grutter versus Dellinger, you may have heard about it, involving the University of Michigan Law School, the Supreme Court, 5 justices, written by Justice O'Connor, approved an admissions policy used by a state university that included consideration of race. It approved it on the condition that the state not use race as a dispositive, determinative factor about an applicant's fate, but that it could be one of many factors for the purpose of the state interest of achieving diversity in the educational context of higher education, specifically in that case law school, but I think we mostly understood it to mean all higher education, with the idea that a sort of so-called, the term the court used, critical mass of minority students was important to, so that those students who did attend the university by whatever means of their admission would not feel isolated, that the state had a compelling interest in making sure that both for the educational quality that people learn to talk to people that are different from them with different backgrounds and different perspectives, that was an important educational mission, and that the students themselves not be brought in as tokens and asked, to represent the interests of their entire ethnic group or racial group. And to achieve that, you have to have enough that it's not to avoid tokenism and isolation. So that was the holding in Grutter in 2003. Prior to that, Texas had been told that it wasn't allowed to use race at all in its university. And so it had adopted what appeared to be, a race-neutral, what's called a race-neutral approach to trying to achieve some of those same goals that Michigan was trying to achieve of diversity in its universities. And what it did was to say the top 10% of every high school in the state, if this was a state university, will be admitted to UT. Why would that achieve diversity? Think about it. They're going to be, because they're exploiting the racial segregation in the housing patterns and school patterns in the state, because some of the schools will be largely minority schools, and you will try to produce a critical mass, again using that court's term, which is not a great term, and it's subject to a lot of, I think, criticism. But anyway, so they had this so-called 10% plan in place. It was working somewhat. But after Grutter was decided, Texas did a study, and they actually did a lot of work, more than you usually see in these cases, where they did surveys and they interviewed students, and they found that the minority students, by and large, felt isolated. There weren't enough of them. That this process was not producing a critical mass, and that it was failing in its job of making everyone feel included and feeling as if they are an integral part of the educational population. So Texas wanted to do more. So in addition, it kept the 10% plan, but now that Grutter had given a stamp of approval for considering race, for the rest of the class, which turns out to be about 25% of the students that were not supplied by taking the top 10% of every high school class, for the rest of those students, they would take a plan that was modeled exactly after Grutter. So it was modeled after Grutter. It should comply with Grutter in isolation. Abigail Fisher applied to UT. She wasn't one of the top 10% in her high school, so she didn't get in that way. She wanted one of the other seats. She didn't get one. She didn't know why, but she challenged it on the ground that it must have been because of her race, which was Caucasian, and so she sued. And her claim is, I think it's a little hard to know exactly. Maybe you guys will help clarify. To me, it seems she claims she's not challenging Grutter itself, because Grutter was only decided, 9 years ago. You don't usually go to the Supreme Court and say, overrule a case that you decided 9 years ago. You usually go to the Supreme Court and say, this fails the test imposed by that prior case. And so she claims that because the 10% plan, in her view, was already in place, it's race neutral, so it's not as objectionable from a constitutional point of view, and it was, in her view, again, supplying enough diversity. They didn't have a justification for going to the race-based plan, race-conscious plan that Grutter had upheld. And indeed, the opinion in Grutter did sort of go to lengths to say it has to be necessary and it has to be a last resort. So I think her claim basically is it's not necessary because you have this other thing that's working okay. So I don't know. So what's interesting, I think, in terms of dynamics, and then I'll turn it over to these guys to analyze it, but Justice O'Connor wrote the opinion in Grutter. She was replaced by Justice Roberts. Justice Alito, excuse me. Justice Alito, who has made clear that he is very unsympathetic to race-conscious actions. So that's one substitution that you might imagine could cause a change. And Justice Kennedy, who we now think of as the swing justice, was in the dissent in Grutter. He was not one of the five who upheld this. He wrote a separate opinion, though, really interesting. He's such an interesting person on this issue. He wrote an opinion in that case saying, I'm voting against it because I don't think it really was narrowly enough tailored. It's not necessary, but I don't agree that you can't ever do it. And then in an intervening case involving lower schools, parents involved, Justice Kennedy again wrote a separate concurrence, even though he went along with Chief Justice Roberts' negative striking down of a race-conscious plan. Justice Kennedy said, I don't want to agree with you that you can never happen. It's important. Sometimes it's important to acknowledge race in order to address lingering damage caused by race. He won't say exactly how, but he's clearly open to it. And Justice Kennedy is someone who cares very deeply about individual dignity, and it offends his view, I think, of that, his understanding of individual dignity for a person to be denied or an application based on their race. So he doesn't like affirmative action, but if you can show him, and if he recognizes it as an individual dignity issue on the other side, that the minority students might have an individual dignity claim to have a critical mass and to be included in a state that until 1950 segregated students by law and did not allow any of them to go, any African-American students to attend the University of Texas. So I think that it's a very interesting question whether Justice Kennedy will, in a new context where he's in the middle, where O'Connor isn't there to do the job, whether he might reconceive his view on this and possibly save it. But I'd be very interested to know what you guys think about that.
Let me just say this, that in Grutter, the 2003 case, Justice O'Connor and very famously wrote, we expect 25 years from now, the use of racial preferences will no longer be necessary. Well, it isn't 2028. The Supreme Court took this case, and I want to get back to a question Professor Brown hinted at, which is, why did they take this case? Can we expect to see a major change in this area of the law? Professor Dellinger, what do you think?
Well, I think the only reason, certainly those who defend the University of Texas's program, and I should note that along with my colleagues at O'Melveny, filed a brief for the Mexican American Legal Defense Fund and 25 other Latino Hispanic organizations with their perspective on this case, defending the University of Texas. I mean, my concern is that the court would only have taken this if they're prepared to overrule the University of Michigan Law School case, either in one step or two. That is to say, the Texas program seems so modeled on what was done in the University of Michigan, where every application is considered individually. A large number of factors, in fact about 17 are taken into account when you look at these other sort of personal achievement factors that are taken into account in Texas in doing it. There are no points awarded for race. No one ever has to decide, is this person actually a Latino or not, which the Michigan undergraduate program, which was invalidated, required the admissions office to do. Everything is decided so you can look, is this, I don't know whether they use alumni preferences as at the University of Texas the way they do at so many private schools, but there's so many other factors. Can this be, one of those factors? The Michigan Law School case said yes. Here the only argument is, it seems to me to be a complete standoff in terms of whether it's any different from Michigan. They say the 10% program means that you do have a significant number of minorities, of African Americans, of Latinos who come in just by the nature of the fact that you do this. On the other hand, it means that the use of race is playing a relatively small role in this, but commensurately smaller role than it did at the University of Michigan, because it plays no role at all, and at least as a formal matter, in the 10% program. So it's not clear to me why you could draw a meaningful difference between Grutter in this case, which is not to say that the court doesn't sometimes go in two steps, but I would really think that the Michigan Law School case is very much in play here, even though that's not been the central claim put forth on behalf of Ms. Fisher. Paul, do you?
Yeah.
Well, I mean, I think, everybody's pointed to what I think is really the right question here, is why did the court take this case? Because in addition to the Grutter clock still having a number of years left on it, I mean, the other point is that, this was a case where there were some real questions about this particular case as a vehicle for Supreme Court review. The plaintiff in this case, I understand, has already graduated from another college. This was not brought, usually the way you sort of get around that is to bring it as a class action, but this wasn't brought as a class action. So there are real questions about whether, the case is really moot as with respect to the particular plaintiff in this case. The Texas filed a brief in opposition, which I thought was exceptionally well done and did a very good job of marshaling all these arguments about how, whatever you think about Grutter and Gratz and the future of affirmative action, this just isn't the right case to do it. The Supreme Court relisted the case a number of times, so they obviously had some concerns about some of these issues, but they ultimately took the case. And, I don't really have, sort of a substantive prediction, but, for those that were fans of, kind of diversity and affirmative action and breathed a real sigh of relief after Grutter, I mean, I think it's time to be nervous again, because, this was not a case the Supreme Court had to take. This was a case that they, went out of their way to take, notwithstanding there were some real kind of case-specific reasons to think it might not be the best vehicle.
But it takes 4 to grant cert, and it takes 5 to overrule Grutter. So there may be assumptions about Justice O'Connor being replaced by Justice Alito that may or may not turn out to be right.
I think this case may say a lot, already says a lot, on the issue of judicial restraint. And I don't just mean that in the normal way. It's a very aggressive grant of review for the reasons that Paul suggested. We have a situation now where we came within a single vote of the court invalidating the Affordable Care Act, which was an enormous undertaking, on the grounds about whether you could read the 2.5% penalty as separate or not from the mandate, which is, however convincing the technical arguments may be, seems to be, it's bearing a lot of weight to invalidate a program. So that all of a sudden you have a court now whose conservative members would invalidate campaign finance regulations, came within a hair of invalidating the Affordable Care Act, undertook now to review affirmative action in higher education, when we'd sort of reached a point of stasis in this. When I was a young professor, when Bakke was decided, and Lewis Powell drew a distinction between quotas and the softer taking into account the way you do alumni, parentage, et cetera. As a young professor, I made mincemeat, I thought, of the illogic of Powell's line drawing and showed how smart I was because his distinctions couldn't withstand logical scrutiny. And about 30 years later, when the Michigan case came around again, I realized that Powell's opinion was just as lacking in logic as I thought as a young professor, but I realized how profoundly wise it was, and that LSAT logic chopping isn't all there is to wisdom, that he actually had he gone with the 4 justices who thought there were no limits on the affirmative use of race in a situation where you've had a dominant culture, Alan Bakke would have been removed from medical school during his 3rd year. The mandate would have gone into effect. We were at a flashpoint over this issue. Had he ruled with the more conservative justices, it would have meant all of these other factors could be considered, and the answer on race was 0, not ever, which meant that you couldn't do it for the police force if you're worried about how you're going to police a disparate community. If it spilled over to Title VII, you're trying to run a metropolitan newspaper in Miami without taking into account the sort of diversity that you would need. And lo and behold, most critically, you're going to try to run the U.S. military, whose officer corps they had found in Vietnam was sort of heavily white, and you had a heavily minority enlisted corps in countries around the world. Their operational needs. That it makes for a better university, makes for a better police force, makes for a better police department. This is not about reparations. This is about being able to do all of this. So we had reached a sort of stasis, and O'Connor, I was like one of the few people in America that thought she was right both ways, to invalidate the undergraduate program, to uphold the law school program, because one required you to make a racially identifying judgment and the other didn't. But I thought, well, we've reached a point of peace on this. So the court has taken a stick on the behalf of someone who has now gone on and finished and graduated from LSU. To reach out and grab this case now seems extremely, aggressive, and is in some sense like the Louisville decision that Rebecca mentioned, parents involved, where the city of people in Louisville and in Seattle, Washington, tried in pupil assignments to try to have some integration in the schools. And the court 5-4 struck that down. And both the Chief Justice and Justice Thomas said this is just like the use of race under Jim Crow. And I thought that profoundly misguided, though all uses of race may be problematic and you want to look at them carefully. The idea that this is just the same, this was invalidating what's been done by communities around the country, everything conservatives should abhor in terms of setting aside local school education choices by a central court in Washington, D.C., setting aside what white and black people had actually, both communities supporting this plan in Louisville, Kentucky, and where I think it utterly different from what a black parent had to say to a child about why you can never go to an amusement park, you can never go to the swimming pool, you can travel across the South, and you can never go to an amusement park, you can never use the hotel. This whole system your children brought up in, it is not like telling a child, next year you go to PS 110. The only time it'll happen to you in your high school career in Louisville is likely to be once, because we're trying to make sure we have all of our races have some exposure to each other. That's not the same thing. I thought when I read the Louisville opinion, which I think is, I'm afraid, the precursor to where they're going to go in Fisher, that the logic that says that this kind of use of race, particularly as it was used in Louisville and Seattle, is exactly the same as the Jim Crow regime that I grew up in the South. To think those two things are the same flunks the first test, the first lesson taught to preschoolers on Sesame Street. And that is, which of these things is not like the other?
Well, I think, assuming they did not take the Fisher case to clarify mootness doctrine, I think we have some agreement among the panelists that this is an important case to watch this term in terms of changes in doctrine. I would like to move on to another case the court will decide this term, and that's Keobol versus Royal Dutch Petroleum. This is a case that the court heard last term, but ordered a second round of briefing and arguments for this term, and it just heard the case, I believe, on Monday, the first day of the term. This is a case that has attracted, very interesting, a lot, not just a lot of amicus curiae, friend of the court briefs, but a very diverse set of amicus curiae briefs. We see bar groups, human rights organizations, historians, business interests, and the U.S. government filed. Mr. Clement, I know you are involved in this case, and I'm wondering if you can explain not just the basics to us, but why this is so salient and so interesting to a wide range of groups.
Well, I'll give it a try, and in the interest of full disclosure, so of these many amicus briefs, I filed one of them on behalf of IBM and some other corporate entities that are very concerned about the scope of the Alien Tort Statute. And what I would say about the Alien Tort Statute in this Kiabel case is this was supposed to be kind of probably the most significant case for the business community in last Supreme Court's term, but it actually got carried over and re-argued on a different question in this term, and that makes it one of the most important cases for business in this Supreme Court term. And just if you stop for a second, that's kind of a funny thing to say, that an Alien Tort Statute, which is a provision of law that's been on the books since the Judiciary Act of 1789, would be of such surpassing importance to the business community. But there's an explanation for this. So the statute roughly says that there's jurisdiction in the United States for courts for an action in tort only by an alien for the violation of the law of nations or of a treaty. And as I said, this was included in the Judiciary Act of 1789 and pretty much was not noticed for 180 years. And then in roughly around 1980, some enterprising lawyers who I think were genuinely interested in human rights abuses abroad and were interested in kind of making almost more of a point about exposing the human rights abuses abroad, sort of stumbled upon this statute and sort of looked at it and said, alien, tort only, violation of law. We could sue Pinochet or something in the U.S. courts and expose the horrible human rights violations there. And the Second Circuit, I'm vastly oversimplifying, but basically said, yeah, you can do something like that. And then another group, and this is where the corporate community comes in, another group of even more enterprising lawyers said, well, that's all well and good, but there's not really any money in that because, the governments have sovereign immunity. Most of, so there's a couple of deposed leaders that have some money, but, they've hidden it all. So there's really no money in that. So here's a great idea. We'll use the same statute, and we'll say that United States and foreign multinational corporations aided and abetted the human rights violations in the foreign countries. And that way we can get at somebody who can really pay, and we can do good and do well all at the same time. And again, the Second Circuit and the Ninth Circuit, I'm simplifying here, but allowed those suits to go forward. And so it's now the case that if you're a Fortune, say, 200 company and you have any operations abroad, chances are you've been named in one of these suits for aiding and abetting some atrocity that's happened in a country where you do business. And so the court takes this case last year, and it asks a question that I think a lot of people, myself included, kind of thought was the wrong question. And the question they asked was, can a corporate entity be a proper defendant in an Alien Tort Statute case? And that's an interesting question, to be sure, but I don't think a lot turns on it. And I guess the way I'd illustrate that is one of my clients in this case kind of told me that, if all the Supreme Court decides is that a corporate entity cannot be a defendant in one of these actions, but individual corporate officers can, that's going to be a tough conversation to have with the executive suite. The good news, XYZ Corporation can no longer be sued under the Alien Tort Statute. The bad news, well, the CEO, the CFO, they can all be sued in their individual capacity. That's a hard conversation for the general counsel to have. So that's not something that, it's important, but the real issues were whether or not the statute could apply extraterritorially, because most of these cases are brought about human rights abuses that take place abroad. And then the other question that's very important is whether or not you can have aiding and abetting liability, because that was really the ticket to get the corporate defendants in the case. And so a couple of folks, including myself, filed briefs last term and tried to sort of say that there are these other issues that are quite important. And quite surprisingly, the court said, we're going to hold this over for re-argument, and we're going to have argument on the question of whether or not the statute can apply extraterritorially, and if so, to what extent? Now, I think that starts to explain why so many people are interested in this, because if you're a group that is interested in trying to police human rights abuses abroad, this is a very important issue to you. If you're somebody who is on the plaintiff's side of the bar and you've made a fair bit of money in this area, it's important to you. If you're a corporate defendant and you've been subjected to these suits, which are really very difficult suits for the corporations to deal with, because it's not just the financial exposure, but it's the combination of kind of being linked to these horrible abuses at the same time that you probably at some point have been told by some government official, either U.S. or foreign, that actually it would be a good thing if you invested in these countries, and actually if there's more foreign investment, there'll be more jobs, and there'll be less human rights abuses in the long run. So I think the corporations both feel like these are bad suits because they are being linked to very repressive regimes and very bad conduct, but also because they kind of feel like they're being punished for doing what people told them they should do. And so you combine all that in one case, and it's no surprise that you have all these varying people sort of filing these briefs. And the only thing I'll add is, even though the first argument was focused on this corporate liability question, but even at the argument you could tell the justices weren't satisfied with that, and they were asking about all sorts of other things. So they add the extraterritoriality question. So you'd think Monday's argument would be focused like a laser beam on that, and the justices would be really satisfied with only talking about that. But again, they're talking about everything.
Right.
I mean, just all sorts, exhaustion of remedies, personal jurisdiction, should these suits be brought in Nigeria or in the Netherlands? And so, I have to say, having read the argument transcript, I think that they will do something to make it harder to bring these suits. But it's not clear to me exactly what they will do. And to give you a sense of how difficult I think it's been for the court to figure out exactly what they want to do here, they've had one other modern case that's wrestled with this statute. The federal government at that point and the defendants at that point give a lot of arguments for why these suits should really just not get off the ground. The Supreme Court, in its decision, basically credited every one of the arguments that had been made for never having these suits, and it said that's why we should hardly ever have these suits. And then the line that's stuck with me from that case, the Sosa case, is that the dissenters and some of the parties want us to shut the door on these suits. We will keep the door ajar, subject to vigilant doorkeeping. Now, I got to say, if I were a lower court, I'd be hacked off about that direction, because it's a pretty tough assignment to do vigilant doorkeeping. So,
It's a mess.
Professor Dellinger, do you have any, or
No,
Professor Brown, any thoughts about
when this case was argued, this particular case is brought against Royal Dutch Petroleum, which is a British and Dutch company by Nigerian citizens for atrocities committed in Nigeria, that it is alleged that Royal Dutch Petroleum aided and abetted. So it's Nigerian victims, Nigerian perpetrators, possibly aided and abetted by a British and Dutch company. And what's missing from that description is any mention of the United States. So that when the question came up on whether corporations could be defendants or whether only natural persons could commit human rights violations, the court said, Justice Alito said, there's nothing in this about the United States. Why are we the courts of the world? So I think it would be agreed that the 1790 statute does allow, if you are a British citizen in this country and in violation of a treaty, your property is taken, or a British citizen is tortured in violation of a human rights norm in the United States by a natural person who is the perpetrator, that there is jurisdiction in the federal courts for the tort by the victim against the perpetrator when it's a U.S. perpetrator, U.S. event. So it's clearly that much that Congress had in mind in 1790 of providing this remedy to aliens. But when you add the fact, all of these other potential elements, that it's aiding and abetting liability, that there are foreign governments involved, which raises foreign policy considerations, that the plaintiffs are not themselves U.S. citizens or even necessarily in this country, that the court is wondering where all this is going and looking for some ways to put limits on the scope of this litigation. And they really, I agree with Paul, they seem to be having a harder time figuring out what was the issue that they were going to be voting on. And that is going to be, the conference of the court is going to be, well, what is it we're voting on here?
Could I just say one thing? Because I just think there's something missing from this, which I just want to put in there to make it a little more complete, which is because it makes it sound a little bit preposterous in a way when there's no tie of U.S. interest. But the concept, at least arguably, and the history of the statute, of course, is debatable, but was that there are some things that are so bad that it's a global issue. And the Congress of 1789 arguably took a stand to say when something is done, there was a Latin word that means the enemy of all mankind or something like that, that is created by an enemy of all mankind, there should be a forum to litigate that when all countries agree. And the Supreme Court has limited the torts that can be brought to very few. Genocide, only those that are indisputably acknowledged by all as human rights violations. So we're not talking about minor things. We're talking about genocide, war crimes, torture, I think, and maybe a couple others. Very, very high standard of what can be brought. And notice the substance of the tort is not supplied by U.S. law, which is usually what we mean when we talk about extraterritoriality. You usually say, oh, our law, you're making somebody outside our borders conform to our laws. That's not what this is. The U.S. is providing a forum, a place to adjudicate a violation of law that is international law and is recognized universally as such. So it's not so preposterous. I mean, it still might be wrong. I don't know. That's the issue, I guess. But it might be a bad idea because of foreign relations, and the U.S. government's a little concerned about some of its relations with, say, Nigeria or whatever. That might be a good issue. But it's also, I think, worth pointing out that some of those amicus briefs, there's one, I think, by Argentina, for example, saying this is the important tool for shining the spotlight on oppressive regimes when there's no other place to go. And that might be a possible limitation, which is to say you can bring it in the U.S. if there's absolutely no other place. Do you think these Nigerian plaintiffs can bring their claim in Nigeria? I mean, not so much, right? So that's the question.
Let me say, our time is
just
growing
one
short.
quick comment on it,
Sure.
because it's certainly true that certainly after World War II, the concept that there should be universal jurisdiction over human rights abuses is a very important concept, and particularly when a jurisdiction might be the jurisdiction of last resort when you can't go to another jurisdiction, which is why it's interesting that in the oral argument, and this is in a sense in addition to all the other issues, several of the justices were asking about the fact that here the defendant is a Dutch and British defendant. And the plaintiffs were asked, are the courts open and available in England and in the Netherlands to hear this case? And one possibility would be that you would recognize universal jurisdiction on behalf of a plaintiff who said, we need this as a forum because the more appropriate forums are realistically not available. And that wouldn't be the case in this instance.
So thank you very much. It's a really interesting case that I think we'll all follow. Our time is growing short, and I would like to open it up, but I do want to just quickly talk about a set of pending cases. The court has not agreed to hear these cases yet concerning same-sex marriage. One is a case most of us in this room know about, the Perry case, which deals with the California Proposition 8. But there's also a set of cases that are challenging the federal Defense of Marriage Act, DOMA. And Mr. Clement is actively defending DOMA. I guess maybe somebody will pick up on this during the Q&A. I'm just wondering quickly, are they going to take the DOMA case, Perry, both, or neither?
Well, I think, and take this with a grain of salt, since I'm involved in the DOMA litigation, and I'm not involved in the Perry litigation. I guess my perspective on this is I think it's going to be very difficult for the court not to take the DOMA cases, because there is a general understanding that absent unusual circumstances, that when a court of appeals strikes down an act of Congress as unconstitutional, the court will generally take that case up. And the First Circuit Court of Appeals in Massachusetts has already ruled on DOMA and has struck down the statute as unconstitutional. Cert petitions have been filed in that case, and then other cert petitions before judgment have been filed in other cases. And so, you have kind of, with respect to DOMA, the classic criterion for the court taking a case, which is you have an act of Congress struck down as unconstitutional. On top of that, you have, the kind of unusual dynamic here, which is you have the executive branch that usually is in the business of defending federal statutes. They have decided to not defend the statute, but what maybe people have focused less on is while they've decided not to defend the statute, they're still enforcing it. And so that creates kind of this dynamic where, if the court doesn't get in here and solve this issue and resolve it once and for all, these cases are going to keep on coming up because the executive branch is, on the one hand saying we're not going to defend the statute, but on the other hand saying, well, but we're still not going to give, a same-sex couple a tax deduction, or maybe even more dramatically, we're not going to allow a same-sex, spouse to stay in the country in an immigration situation when we'd allow it with an opposite-sex couple. And so these cases are going to kind of proliferate. So I think for those two reasons, the court is quite likely to take the DOMA case. I'm usually quite reluctant to say the court's going to take any case. I'm particularly reluctant in any case that I'm involved in to say that. I feel like I have a little license here because Justice Ginsburg has pretty much already said that they're going to take the DOMA case. So then the really, I think, interesting and question where I don't really have a clear view is whether they would also take the Perry case. There's another case out of the Ninth Circuit called Brewer that involves benefits, an Arizona case that involves benefits. So, they could take as many as 3 of these cases, but I also think it's quite realistic that they could take the DOMA case, decide that case, and maybe hold Perry and GVR in light of that or something like that, but not take Perry up on its own. So I think that's, either one of those wouldn't surprise me one way or another. I don't know, do you have a
Thoughts on
No,
Perry?
I think it's certain that the court will take one of the DOMA cases. One of the complications is that the first case, the one which has already been decided by the First Circuit, is a case in which Justice Kagan may have participated when she was Solicitor General. It's listed on the cases she submitted to the Senate at the time of confirmation, so she may be recused in that case, which is a complication. None of the justices would want to take a case in which she was recused because it would simply not, you're not going to get a resolution that's, it doesn't matter which side you're on. So partly for that reason, there is an application for cert before the Solicitor General has asked the court to consider taking one of the other cases that hasn't yet been decided by the Court of Appeals, which the Supreme Court has the right to do. DOMA is a really important case, and I think from my vantage point, one that I very much hope will be the next case decided by the Supreme Court, and not Perry, not the Prop 8 case. DOMA is critically important. To make it clear, the provision, Section 3 of the Defense of Marriage Act, provides that for any purposes in federal law, and there must be, how many provisions, Paul, would you think of federal law? We're talking
probably 1,000.
Maybe 1,000. The term spouse or husband, wife, spouse is used in federal statutes. There may be some contention over this, but generally speaking, Congress never defined what's a spouse, but the law of the place in which your marriage was domiciled would determine whether you were qualified to be a spouse. There was no independent federal rule on it before DOMA. But DOMA comes in and overrides state law by saying, regardless of what state law provides, you are not a spouse for purposes of any of the federal statutes unless you are a couple of an opposite sex to the other partner. And it's just, you would just be amazed at how many cases. I guess the Windsor case out of New York is one where 2 women who have been in a long-term relationship, married under the state of New York, once New York dropped its opposite sex requirement for marriage. They're married. One of them died, and the estate would have normally passed to the spouse without estate taxes being applied, because your estate passes to your spouse without it being a tax. But the IRS takes the position that they have to, under the Defense of Marriage Act, that they cannot recognize these people as married, even though they're married in the state of New York. Now, what I think advocates for gay marriage like about the DOMA case is that if Justice Kennedy is the swaying justice, the argument is that states' rights and gay rights are on the same side. And he has been to vastly oversimplify, a pro-gay rights and a pro-states' rights justice. But in this case, he doesn't have to choose, because it's the judgment of New York and the other states which have allowed marriage among same-sex couples that is in a sense being overridden by the national government. That's why it's if you think in terms of sequencing litigation strategically, it's the next best case to come along. And I think there are a number of problems with the Prop 8 case, which we can go into, that make it not a good case. If we have a chance, I'll talk about what those are. But
Great. Really appreciate the clarification. I am going to open it up now to questions. You'll need to go over to the mic if you'd like to ask a question. Our time is extremely limited, so please ask your question quickly. I will, unfortunately, have to cut you off if we don't get to the question right away.
And can I just encourage our students to take this opportunity to, of course, I know a lot of answer, but one of my rules is became a privilege, is to have my students have the first shot at any questions.
Well, I'm not a student, and I'd be glad to put myself behind the students, but I'll go ahead. Chief Justice Roberts surprised our nation by ignoring the Commerce Clause and voted to tax a person 2.5% if he or she does not cover herself or himself with insurance. What 2%? What 2.5%?
2.5% of adjusted gross income. When you file this is not a universal requirement. Certainly now, as it's been read, it only applies to people who have taxable income above $20,000 who are required to file federal income tax. And when they do, there's another line where you pay. If you don't note that you have minimum health insurance coverage, you have to add an additional 2.5% to your income tax. So thank you, because we should have made that clear earlier.
I think there's also a significant area of litigation coming up about, in the realm of election law, that's going on with provisional ballots, voter ID laws, and all of these are sort of working their way up the courts right now. And then another handful of legal experts think that the court might have a repeat of 2000. I wonder if the three of you think that that's likely to happen, if any of these issues will attract the court's attention before or even after the election, and how that might, how the court might view the election issues coming up.
Well, I think one of the election-related issues that's headed to the court is the issue of photo IDs, and particularly in jurisdictions that are governed by Section 5 of the Voting Rights Act. And we appropriately focused on the cases that are already on the court's docket. But I think one issue that's quite likely to get on the court's docket this term is a question that will either arise there's a Shelby County case where a petition's been filed that is kind of a more facial attack on Section 5 of the Voting Rights Act, and then the same issue could arise as applied in a voter ID context or another context. And what Section 5 of the Voting Rights Act is a provision of law that basically says that for certain covered jurisdictions, and there's a coverage formula that was not really disturbed in the last reauthorization. So you have, it's kind of an interesting list of jurisdictions. There are a lot of kind of jurisdictions in the South, but then Alaska is a covered jurisdiction. A couple of counties in California. The Californians here probably understand better why Monterey County's in, but other counties are out. But in any event, you have this kind of list of jurisdictions, and unlike the rest of the jurisdictions in the country where if they want to change their ballot access or they want to change and say, we'd like a photo ID, they can just do it, and then the burden's on somebody else, some litigant, to go in and say, no, that's a problem, enjoin that or stop that. For these jurisdictions that are covered by Section 5, they basically have to go to Washington and either get clearance from a Justice Department official or from a 3-judge court in Washington before their law can even go into effect. And so those issues are coming up in the voting ID context, both Texas and South Carolina. And I think either this term or next, the court's going to have to decide, one way or another, if those jurisdictions can have a photo ID requirement and or whether Section 5 continues to be constitutional. So those are at least some issues in that area that I think are headed the court's way.
Professor Brown, did you have something
Well, I was just
to
going
add?
to say, it doesn't look to me, tell me if you disagree, that the Supreme Court will get involved before this election, because that would be pretty extraordinary. They'd have to have a really good reason, and what I've noticed happening mostly is a lot of these courts are blocking implementation of some of these voter ID requirements until after the election if they think that it can't, that IDs can't be produced in time or whatever, which means that it would be unlikely there'd be an emergency that would warrant the court stepping in. But they will definitely have to address the issue, but I'm hoping it won't be chaos right at the moment of the election.
Well, it's just extraordinary the degree to which the court has become involved in politics in the election process. I mean, I think you can divide the world into before and after 2000, perhaps earlier, redistricting, Baker versus Carr. But when you think about it, the court's intervention in the 2000 election brought about the presidency of a president who replaced Chief Justice Rehnquist and Justice O'Connor. The court then has struck down limits on campaign finance expenditures. The court declined to strike down voter ID law from Indiana. Now has on its potential agenda invalidation of the provision of the Voting Rights Act, which requires what's called pre-clearance. Now, let me say a word about that. This is an enormous historical importance, and the question is, are we sufficiently removed from history that the court is going to feel free to strike down this critical part of the Voting Rights Act? Before 1965, the 15th Amendment was a dead letter in almost all of the old Confederacy. That almost all African Americans were simply denied the right to vote on the grounds of race, and if they sued, there would be one more trick or device after the other. And the Congress, and I think by far the most important of all the civil rights laws, invalidated all tests and devices. There were barriers to voting. And said in these southern jurisdictions that you couldn't adopt any new change in the law without getting approval of the Department of Justice or a 3-judge court in Washington, D.C. Very dramatic. Certainly, I think a majority of this court would find it as a fresh matter extraordinary to require a state to seek advance permission before putting a new state law into effect. But it did that, and it was the only way to solve this problem. And it did it under a coverage formula where it didn't name the states. Congress couldn't have said this applies to North Carolina and South Carolina and Virginia. It was a complicated coverage formula about minority participation in voting, et cetera. They took in the old Confederacy and a few other places as well, Alaska and some isolated counties. Now, when it came up for reauthorization the last time, Congress didn't use any new data. And the justices that are inclined to invalidate the act now as beyond Congress's power say that it's no longer rational because you didn't use any new data. Is North Carolina really that much worse now than, I don't know, Idaho, whatever, on these issues? But the problem for Congress was to reopen the coverage formula meant that delegations would have to vote against their own state to denominate it. It was a powerful historical and practical political reasons for keeping with the old coverage formula. So I think it's a huge question. It is odd that something like voter ID, which can be used, in my view, is an unnecessary restraint on voting that fails to achieve a legitimate objective that's likely to be invalidated in the old states of the Confederacy and likely to be valid in cases like Indiana. Does lead to an oddity. But the court is still circling around the important issues of election law in a way that makes a very small number of people play a very central role in in the way our country is governed.
With that, I think we're going to have to thank our panelists so much. We could probably talk for another couple of hours.
Thank you. I have said all I think there's no standing in Prop 8. I think it's...
Yeah.